vacation, but we can also take a call whether to amend the definition or what stand the government would like to take. That's otherwise, my lord, we are ready and we will. We can then put it out.
Then, because anyway we have now two days this week and 3 days next week.
Only 1 week, practically, my lord, 1 week. Because yesterday, tomorrow, your lordships have fixed some, my lord, the judges matter also, and this can't be over in a week. The industrial dispute matter can't be over.
We can keep it in July on the reopening. We'll notify the date.
Yes. My lord, kindly come to volume 2D, capital D, my lord, D for Delhi. Lord, my submissions on Article 39. But before that, my lord, I would wish, my lord, your lordships to see Article 37, which is not, my lord, of course, your lordships would be knowing about it, but it's not brought to your lordships' notice in this matter, my lords. That would show, my lord, the sanctity which the framers of the Constitution have attached to directive principles of state policy. 37, my lords. But last lines, my lord, are, in my respectful submission, yes, my lord, even lawmaking. No, not, my lord, just executive governance, even in lawmaking. Application of the principles contained in this part. The provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country, and it shall be the duty of the state to apply these principles to making laws. There is a constitutional obligation, so to say, on the legislature also to apply these principles. Now, my lord, kindly come to, my lord, my note, volume 2D. My lord, the width of Article 39, because, my lord, your lordships, obviously, my lord, would bear in mind the question, my lord, which is being, for which we are assisting your lordship is whether a private property would fall within 39 or not, my lord. In that context, my lord, this is my perception of Article 39. The ownership and control of material resources of the community are so distributed as best to subserve the common good. My lord, each word in my respectful submission, my lord, is, my lord, pregnant with meaning of making a welfare state. My lord, if I have to, my lord, give one word for this entire article, it is to create a welfare state, my lord. Now I would dissect, my lord, why each word is used very carefully by the framers of the Constitution. But it says ownership and control of the material resources. My lord, if the framers of the Constitution would have envisaged that the property owned by the government to be used for the purposes, my lord, which are mentioned, then there was no occasion for them to say that ownership and control would be used. Ownership and control would necessarily mean that something which do not belong to the government, but in the larger interest of the common good, there can be a law passed
These have to be resources of the community.
I'm coming to that, Manoj. The word used is not material resources of either the state or the government. It says resources of the community, which again leads to an indication that it includes both government property and other than government property.
Learned Solskjaer, you must have, since we are on 39B,
My lords.
and you are proposing to dissect the words there. Now, obviously, you are also going to look at, now when you say ownership, not with the government, it is obviously in the private sector,
Both.
right?
It can include both.
It can include both.
Both.
So ownership and control of material resources, as the Honorable Chief Justice has pointed out, and what is to subserve the common good.
I'm coming to that.
Right. This common good element is very important because
That's the, my lord, key word in the entire section.
that's right. So whether common good, of course, this is in the context of the provisions in the MADA Act. Whether
In general, we are, my lord.
Yeah, that's right. I mean, you are giving a broad interpretation.
Correct.
The discussion also has to relate to what is contained in the Maharashtra Act.
Yes.
Pertaining to the properties.
Yes, my lord, but nobody touched, my lord, MADA Act from the point of view of its validity, etc. It was just by way of an example. But I am, my lord, broadly, irrespective of, my lord, MADA or any movable or immovable property, any property. Property can be, my lord, a private mine, for example. It is a material resource. It is a resource not belonging to the government because it's a private mine. But therefore, my lord, the key words are, it should be. If any law is made under Article 39B, it should be A, for distribution. B, it should be to subserve common good, not good of any particular section of the society. Therefore, I say common good is the key word, my lord, of this. That you take over some property for the purpose of, say, one section belonging to one race, one religion, one caste, one profession. That is not what is contemplated. It has to be a community property not belonging to the government. It is required for being distributed, and the ultimate goal has to be common good. And therefore, my lord, in one word, this, my lord, provides for an ideal definition of a welfare state. This is not distributive justice.
The question is whether ownership of the community is also equivalent to ownership of an individual, or ownership of a community also encompasses individual ownership of property. That is the question.
My lord, that will have to be, my lord, so read. Otherwise,
whether a community means an individual.
I would answer that question, my lord. It will have to be so read, depending upon the facts and circumstances. For example, my lord, in my house, there is a rare mineral which is discovered. It's not a property of the community, it's a property of the individual. But then the key word would be material resources. If individual property has material resources which can be distributed and ultimately for common good of the citizens.
Therefore, actually, your example is very apposite, because what your example shows is that there may be instances where, in respect of private property, there is a community interest. Now, this is clearly a case of that nature. Namely, though the property is of a private individual, underlying that property, you have say uranium, or you have some very rare, rare resource, which is really a resource of the community. And therefore, there can't be a very strict dichotomy between private and public. At the same time, it is a little too extreme. The formulation by Justice Krishna is a little too extreme. What that formulation says is, since the community consists of individuals, and therefore every individual is a part of the community, if the material resources of the community would therefore mean also resources of the individual.
No, my lord, it will have
That may be a little extreme. I'll tell you
this
also,
would be an extreme, my lord.
it would be a little extreme. Also, we must now be cognizant of the fact that all these constitutional provisions are they have an evolution. We are now interpreting them not in the context of the India of 1950.
Nationalization to disinvestment. That's
Right.
the
Yes.
transition.
Therefore, we must therefore adopt an interpretation which is in keeping with the changing nature of the times and the society which and at the same time, we must also have an enduring interpretation. So it may well be that certain resources which are vested in private individuals may still have some general bearing of public interest or community welfare, the welfare of the broader community, which requires regulation by the state.
Yes, but for example, land, road, making of a road. Lord, land is a material resource when you, when the function you are discharging is making of a road. Lord, some land is coming in between. Lord, it is for common good, for distribution, and it is a material resource, maybe belonging to not the entire community, but an individual. So, Lord, therefore, the law will be in tune with if each and every word is existing, my lord, simultaneously. And I would, my lord, add one more thing.
Also,
Ownership.
39B postulates that there has to be a diversification of ownership and control. Why does it say ownership and control of the material resources of the community is distributed? So this is speaking about the need for diversification of ownership and control to protect the common good. That is, you don't want a concentration of economic resources in the hands of...
If they are material resources.
They are material resources of the community.
Well, it's not, my lord, for example, my lord, a rustic...
Dispersal would maybe or that's what distribution means.
Yes, my lord. Because, my lord, for example, a rustic way of looking at it is that you total up the wealth of the entire nation, divide it by the people whom you feel that needs to be distributed. And whatever is the figure, distribute it. My lord, that's not, my lord, what 39 means. My lord, that would be a lack of understanding of governance as well as economics.
We can't attribute to Article 39B and C, at least in today's times, a sort of a definition which gives, expression to an unbridled agenda of communism or socialism.
Absolutely.
But that is not our economy or our constitution today. We still protect private property. We still protect the right to carry on business. We still want, as part of, say, a national agenda, I won't say the government's agenda, because this is across...
No, it is an agenda of the nation, whichever is the government is.
From 1990. Yes. And so it was irrespective of party lines and government. We have now expressly adopted a policy of encouraging investment by the private sector, realizing that until then it was all right that the government was involved in very high levels of investment in the industry. But now, truly, if we have to have a productive enterprise, you have to encourage private investment.
Yes.
And therefore, our interpretation must also be, nuanced to take care of what India is today and what India is moving towards tomorrow.
Lord, investment in the private sector is now boosting common good than, my lord, what was envisaged in, my lord, 49, 47.
For instance, in 1950, nobody envisaged that you would have electricity distribution by private companies on such a scale. Now you have that today.
Yes.
They couldn't have envisaged that, well, the private sector will be building up infrastructure like roads, like ports.
One of the judgments, very illuminating judgment. For example, airports, my lord, some of the activities are, my lord, privatized, not the essential activities like customs, security, etc. But some of the activities are privatized.
We may not have a very strict dichotomy that, well, something which is totally privately owned can never be a material resource of the community. That would be a very extreme statement.
Yes.
But it would be an equally extreme statement to postulate that everything which is private is a material resource of the community, which the Attorney General argued. That may not be
your argument is actually going contrary to what the Attorney General was.
I would, my lord,
in the middle,
a little new nuance, my lord. I would not, my lord, argue contrary to him, but my nuance is different, my lord. Your lordship knows, my lord, what I am trying to say, my lord. And my lord, so far as my lord, the view expressed by my lord Justice my lord, Krishna Iyer is concerned, my lord, it deserves respect. But with respect, my lord, I would personally and on behalf of the government, my lord, would not subscribe to that view at this stage of the
Exactly.
country's economic development.
We be sending a message across, because what we write will send a message of what India is and what
Yes.
India aspires to be.
Yes.
So any interpretation which we look, we don't want to dilute the constitutional or social significance of 39B and C. It's there for us. I mean, it's given to us. At the same time, we should not be sending a message by interpreting 39B in such a wide sense. There is no protection of private rights in the society
Yes.
at all. How will we attract private investment if we say that there's no
Yes, yes.
protection of
It's
audit?
counterproductive. That interpretation may not be in national interest, my lord, but
But
we
we'll
have
not
to-
go as far as to say that anything which is private can never be a material resource of the
No,
country.
that's not, that's another
That
extreme.
cannot be. Yes.
That's another extreme.
Yes.
For example, my lord, in Mada, my lord, if we see, if the government sees that there are, say, 500 people staying in 500 dwelling units, which are in a dilapidated condition, they may have their own justifications for staying, and there is a justification because roof over the head is a justification. My lord, the owner, who is the landlord, he will not spend because he has a justification that I am getting less money. The government is not concerned with their ownership dispute or tenancy dispute. The government would merely say that we are concerned with your life. We provide for a mechanism under which we will evict you. Somebody would pay you the rent for the interregnum till your houses are newly constructed. You fight it out whether you are a tenant, you are a deemed tenant, you have to be evicted, etc. That's not the contractual relationship we are concerned with. So that would be material resources of the community requires proper distribution for common good. So, my lord, therefore I say that each word is pregnant with meaning, and that is how, my lord, we will, your lordships may consider taking a path which is neither on this extreme nor on this extreme.
More balanced perspective
My
on.
lord, that's the
See, for
respect.
example, an individual owner, in this case, an owner of a building which is in a dilapidated condition,
So that we will answer it separately. We will answer it separately.
and this, it all depends to what extent.
My lord, that, my lord, MADA Act and the validity of individual acts, my lord, there are separate answers. There are separate answers to that. But the government would not enter into that area of tenancy my lord, owner-tenant relationship.
Right to develop.
That's not, my lord, the issue. Please, for the time being, Lord, that we have, my lord, our justifications for the purpose of protecting the validity. That was just taken up as an example. Therefore, Lord, I am not going much into it. I am more on a wider canvas for the nation, for the national economy, and the economic growth at which the nation is progressing at this stage. What should be the meaning of
So
this?
how would you formulate it? So we can just take it down, it'll just give some clarity to us. We
Yes,
can
my
just
lord,
take a
my
moment
formulation
so
is
that
this,
You
my
can
lord.
reflect on it and tell us.
Lord,
How would you formulate
Yes,
it? We
my
can
lord.
just take it.
The 39 small b is a measure for developing
A little slow.
a welfare state with the ultimate goal of common good. I'm sorry, madam.
Goal of protecting the common good, we'll say.
Common good, the ultimate goal of protecting the common good
Or achieving the common
or
good.
achieving, my lord, I'm sorry, madam. When material resources of the community needs legislative intervention of either taking over ownership and this is my nuance, my lord, and oblique or control. The Constitution says and, but I am saying it can be read even as or. Lord, sometimes, Lord, why I say or? Lord, suppose there is a private mine. The government may not take over the
How would we
ownership.
but you have to complete the sentence.
I'm sorry.
When material resources of the community need legislative intervention or taking over ownership or control,
To achieve, my lord, that common good of the
I'll tell you how you began.
control of the material resources. I'm
Article
sorry.
39B is a measure for developing a welfare state with the ultimate goal of achieving the common good. Then is it comma when material resources of the community need legislative intervention of taking over ownership or control?
Of ownership or and oblique or
And
control
or control.
For taking.
of material resources
Need
of
legislative intervention of taking over ownership or control
and oblique or, my lord,
and or.
because Constitution says and or is, my lord, my interpretation of material resources of the community
For distribution.
For distribution.
yes.
Just going back to this, can we, I mean, we're not putting you into a corner. I mean, it's a thinking aloud. Can we say that you don't accept either of the two extreme positions? I mean, as a government, one extreme position is that every element of private property is a material resources of the community. That's one. Just think over it. Second, that no private property can be a material resource of the community. There are two extreme positions.
My lord, I
One,
think I my
right?
lord, respectfully agree.
Isn't it? Because
I
there are
respect.
two extreme positions that no private property can be a material resource of the
That
community.
is one extreme.
And second, that every private property is a material resource
No,
of the
no.
community. So we don't,
The
we
taste-
eschew both the.
the
Can
taste
we, can we
that-
take it down? Can we take it down? Because,
Yes,
just,
sir.
it'll give us some clarity later on.
Yes, my lord. My lord, the taste, if challenged, my lord,
You'll have to formulate it,
yes.
because then
Lord.
it will depend upon the context.
Exactly.
See, this is, this is everything.
My lord,
This will be maybe the crux of the matter, because then everything perhaps may depend upon the context, upon the situation. As the chief rightly said, the interpretation of the 50s and 60s may not be relevant now.
What?
Constitution, therefore we say it is a
Context.
living document.
It has to be seen
Changes its meaning.
in that way. You have to tell us, and you'll have to also tell us what do you understand, how should we understand community?
Yes.
So that
My lord, may
also
I do one thing, my lord, instead of, my lord, your lordships, my lord, being troubled with writing down, but I'll prepare one paragraph and give it to, that this is how my stand is, but I, my lord, agree with so far, whatever, my lord, the Chief Justice has said, and my lord, Justice Dhulia has said, that it depends upon the context. Depends upon, my lord, what is community. Contextually, it can even be an individual, if the material resources are community-based.
No, I'll give you an example. For example, let us say there is a community, a tribal community, right? They know where a particular herb or something is to be located. Well, now that belongs not to an individual, maybe lying in an individual farm or agriculture field, but it will belong to the entire community, right?
Correct?
But the community, will it be only that tribal community or people of that area or the entire country? That you will have to tell us, because when 39B was being debated, one of the bill was to make it community of, instead of, it should be citizens instead of.
My lord, K.T. Shah, my lord, Mr.
Something. So it was not done. So deliberately this word community was chosen.
To make it wider.
But how wider? When wider and when narrower?
Instead of, my lord, my responding immediately, my lord, can I, at the end of it, give, my lord, my version of it? But so far I am, my lord, completely, Lord, bow down and in agreement with what my lord, the Chief Justice has formulated.
I was just, as you were having this conversation, I was listening to Brother Dulia and you, and I made a note on the context. Now, in the context, we can identify three factors at least. I mean, this I've just done it offhand. One, what is the nature of the resource and its characteristics? Airwaves. Very different from a private property of a different nature. So what is the nature, the spectrum? The nature of the resource and its characteristics. Two, the impact of the resource on the general well-being of the community or the common good. Third, the consequence of the concentration of ownership and control on the common good.
So that may perhaps not be.
Some resources you may not want them to be.
Yes, like uranium. I understand.
Right.
I bow down. That it cannot be with one individual.
Scarcity of the resource.
Yes. Your Lordships, if that melody is added, then scarcity or any peculiar significance of that resource is not left.
These are by no means exhaustive factors. They
Yes.
again have to be evaluated from case to case, from context to context.
Yes, and the class should be identifiable class. The community doesn't mean the entire country. That whatever is there, you take it and distribute it. That's not, my lord, a juvenile way in which the constitutional framers have, my lord, understood.
So the thrust of 38 and 39 is that wealth of the nation or the material resources, as they say, should not be concentrated in a few hands.
If it is
That's the-
required for for common good,
Huh.
and not that it should not be, the government is enabled through parliamentary legislation to intervene and, my lord, take either ownership or control. So there is no prohibition that it cannot be. But if other conditions are fulfilled, then the legislature can intervene.
The word is shall, not 39, 38.
Yeah.
The state shall strive to do so.
Yes, while making the law. Yes, my lord. Therefore, I am saying, your lordships are right, that enabling provision is to make the law where this will have to be borne in mind. Lord, I'll give one paragraph, my lord.
So now what next you want to
No,
formulate?
next, my lord. I'm skipping what is not relevant. Lord, I have given the definitions of control, ownership, etc. But just only one line. Lord, the Constitution says ownership and control. Lord, I would respectfully urge that the words are disjunctive. It can be or also. For example, my lord, why I say so? My lord?
To read ownership and control as ownership or control.
And or both. I'll give the example. my lord. For example, in a private mine, there is a huge tract of land, my lord, belonging to me. And there is some, my lord, a mineral discovered there. The government may not be interested in taking over the ownership of the land. Ownership may retain with me. They will take control over the land. So how much mineral will be excavated? What will be the royalty to be paid? It's
And ownership actually.
Therefore, my lord, I am saying that depending upon the context, it can be ownership and control. It can also be ownership or control, depending upon, my lord, the context. Your lordships can skip the definitions if they are, my lord, quoted only for the purpose of
So solicitor, where are you on the note? Which page?
My lord, up to page 8, my lord, there are definitions quoted. This is only for ready reference. I am not going to read it. Please come to page 9, my lord. My lord, drafting history.
That 9-page note, no?
No, my lord,
No,
I'm
sorry,
sorry.
16-page note.
My lord, volume 2D.
2D.
2D,
Okay, okay.
my lord,
I
I
thought
am
2B.
sorry, my
I
lord,
thought you said 2B. All right.
my lord, I said D for Delhi at the beginning.
Yes,
My lord.
I took it as D. Yes.
Yes. Lord, kindly directly come to page 9, my lord. PDF 11.
So 2B was solicitor's 16-page note. I said solicitor has been uncharacteristic in this case. Now I realize it's 74 pages.
My lord, why I am little longer? Well, there are two reasons. A, I quote the relevant para so that
You
your
have to
lordship
keep
may
on
not have
coming
to
here and there.
shuffle through, my lord, various volumes. And second, my lord, the reason Winston Churchill gave, that I am writing you a long letter because I don't have time to write a short letter. So because you really need precise understanding of the subject to write something crisp.
Churchill or Shaw?
Pardon?
Bernard Shaw, actually. It was George Bernard Shaw.
Yes, my lord.
Isn't it? That's from my recollection. I mean, I may be wrong.
My lord, my lord, there are three individuals. Lord, there are three individuals.
Brother
To whom-
Dulia has made a comment. I think that's relevant.
Be short.
Yeah,
My lord, if it is not a privilege,
No, no, since you are such a
Writing is difficult.
Urdu adab and Urdu literature, somebody said that since I had to write a very small letter had to be written.
हिंदी में बोलिए.
एक छोटा सा खत लिखना था, इसलिए ज्यादा टाइम लगे. छोटा सा लिखना.
yes. And वो नहीं ना मुख्तसर सी बात है.
हाँ, मुख्तसर हो जाइए.
Yes, there is a ghazal, मुख्तसर सी बात है, तुमसे प्यार है. But that's the short thing I want to say. I don't need an essay for that. Mukhtasar means, my lord, short.
It takes more effort to be precise.
That's exactly what, my lord, Churchill or Bernard Shaw or whoever. My lord, these are the three individuals to whom most of the things are attributed. Churchill, Bernard Shaw, and Oscar Wilde. And Mark Twain. Yes, my lord, he is my nephew, Mark Twain. And the same thing happens with Mirza Ghalib. Unfortunately, my lord, completely footpath level शायरी is attributed to him. Last में वो मरीज लिख देते हैं, गालिब लिख देते हैं. Lord, para 9. Lord, what was in the mind of the framers of the Constitution? Well, I'll not read the entire, but Lord, please see the first. Lord, this is the discussion by one Mr. S. Nagappa. Sir, this clause is the only clause where the poor man, the common man, can find some hope for the future. Clause 2 and 3 are identified for the benefit of poor men. No doubt it would have been better if this clause had been drafted in more unequivocal terms instead of in this ambiguous language. As a layman, as a common man, I can see more ray of hope for the future in these clauses. It is the aim of the honorable members who have assembled here to socialize as early as possible. As long as these clauses stand, there is no possibility of capitalism thriving in India. I am very much thankful to the drafting committee and to the president of it, in particular, for having brought in these clauses. And my only grievance is that they have not been drafted in more unequivocal language. Sir, so this is important, my lord. This is now changed. Sir, the slogans today are municipalize utilities and nationalize industries and means of production. And unless and until these things are done, there is no hope for the common man. My lord, now the economical infrastructure and the concepts, my lord, have changed from municipalization, that is nationalization, to, my lord, free trade, etc. Privatization.
Investment.
And that's what Dr. Ambedkar very prophetically said, that it is purposefully not made unequivocal because there can be different ways of dealing with an economic scenario. Then at the foot of that page, para 10, further, Mr. K.T. Shah had proposed the following clauses to substitute Article 39B and C. In that, the ownership, control, and management of natural resources of the country in the shape of mines, mineral wealth, forests, rivers, flowing waters, as well as in the shape of seas along the coast of the country shall be vested in and belong to the country collectively and shall be exploited and developed on behalf of the community by the state as represented by the central or provincial governments. 2 is relevant, that there shall be no private monopolies in any form of production of material wealth, social service, or public utilities, nor shall there be any concentration of means of production and distribution in private hands, and states shall adopt every means to prevent such concentration or accumulation. This was the theory or the thought in those days, my lord. Now, please see, my lord, Dr. Ambedkar's reply, my lord, on 15th November 48. The second reason, my lord, this is Dr. Ambedkar, I quote, the second reason is that the amendment is purely superfluous. My honorable friend, Professor Shah, does not seem to have taken into account the fact that apart from the fundamental rights which we have embodied in the Constitution, we have also introduced other sections which deal with directive principles of state policy. If my honorable friend were to read the articles contained in part 4, he will find that both the legislature as well as the executive have been placed by this Constitution under certain definitive obligations as to form of their policy. Now to read only Article 31, that is draft article now 39. Your lordships can on the side mark that, which deals with this matter. It says, then they quoted the article, draft article, which is substantially on the same line. Then I again read Dr. Ambedkar.
Yes.
But your lordships can now come to page 13, the highlighted part. The question is, it starts with Dr. Ambedkar. Rest may not assist your lordships on the question being considered. Therefore, I am skipping, but I have put it there, my lord, for completion. The question is, have we got any fixed idea as to how we should bring about economic democracy? There are various ways in which people believe that economic democracy can be brought about. There are those who believe in individualism as the best form of economic democracy. There are those who believe in having a socialistic state as the best form of economic democracy. There are those who believe in communistic idea as the most perfect form of economic democracy. Now, having regard to the fact that there are various ways by which economic democracy may be brought about, we have deliberately introduced in the language that we have used in the directive principle something which is not fixed or rigid, leaving it, my lord, for the next generations as world economy develops, as Indian economic growth develops, to take a call which economic model the country would choose. Well, this is very foresight and, my lord, almost prophetic, which is not fixed or rigid. We have left enough room for the people of different ways of thinking with regard to the reaching of the ideal of economic democracy to strive in their own way to persuade the electorate that it is the best way of reaching economic democracy, the fullest opportunity to act in the way in which they want to act. Sir, that is the reason why the language of articles in part 4 is left in the manner in which the drafting committee thought it best to leave. It is no use giving a fixed, rigid form to something which is not rigid, which is fundamentally changing and must, having regard to the circumstances and the times, keep on changing. It is therefore no use saying that the directive principles have no value. In my judgment, the directive principles have a great value, for they lay down that our ideal is economic democracy. Then highlighted part. To lay down that our ideal is economic democracy and also to prescribe that every government, whatever it is in power, shall strive to bring about economic democracy. Much of the misunderstanding under which most members are laboring will disappear. Then, my lord, Shibban Lal Saxena. This is a clause, my lord, he again deals with draft clause 31, the present 39. This is a clause which is very fundamental in our constitution. The character of the amendment suggested also shows that it goes to the very root of the whole constitution. My sympathies are undoubtedly with the amendments of Professor Shah, who has moved 2 amendments, which really suggest that in his clause, we should lay down that the system of our state shall be socialist. In an amendment to the preamble, I have suggested that the word socialist should be added before the word union. I personally feel that particular amendments which he has moved are very important, and I would urge my friend Dr. Ambedkar at least to incorporate the spirit of those amendments somewhere in the Constitution. Part 2 of Article 31 says ownership and control of the material resources are the same thing. Then Malodi further adds, this is maybe important, assist your lordships. Now this enunciation, ownership and control of material resources of the community to be distributed so as to subserve the common good is a very wide enunciation of a most important principle. The enunciation is so general that any system of economy can be based upon it. Upon it can be based a system of socialist economy where all resources of the country belong to the state and are to be used for the well-being of the community as a whole. But a majority in the next parliament can also come forward and say that the New Deal evolved by Roosevelt is the best system and it should be adopted. This clause leave it open to any future parliament to evolve the best plan of their choice.
So what was good for the country in the 50s up to 1991 may not be good after 1991.
Exactly, they wanted
So
to
it
keep
is
it
the
open.
evolving concept, and the clock comes back. We don't know when, after some time, privatization becomes so stressful that we go back to what was good in the 1950s in the decades to come. We don't know.
Therefore, it is left to Parliament.
It's all evolving.
Yes. And my lord, this New Deal by Roosevelt, my lord, is that capitalist
Is in the soon after independence, they said the new dams, Hirakud Dam, Bakra Nangal, they are the new temples of India.
Yes, Bakra Nangal was the first.
Because that is what was necessary.
Yes, absolutely.
But now, after all that development, now the focus is on individual or private development. Country has developed to some extent. Now the private development or the individual development, therefore liberalization, privatization, globalization, investment.
Keeping pace with the international economic development, etc.
LPG.
Lord, just Lord, subject to correction, Lord, out of interest, Lord, this New Deal by Roosevelt.
This is the Second World War.
The Second
After
World War.
29 to 33, not the Second World War, sorry. 29 to 33, when there was a great, the Great Depression.
And those 4 horsemen and 3 musketeers, that's how the Supreme Court used to be consisting of 7 honorable judges, and 4 judges always in majority did not permit Roosevelt to carry out any of these.
Because what happened was all the social welfare legislation like minimum wages, maximum hours of work, they were struck down by the Supreme Court of the UK or the US on the ground that they interfered with the private freedom of contract, or therefore the due process clause.
Yes.
And the due process clause was applied in a substantive sense, so as to allow the court to oversee what policy Parliament was, the legislature, Congress was following, the houses of Parliament were following. And the Justice Holmes was the dissenter.
Yes.
That the Constitution does not permit the court to adopt a policy which a majority of the judges think is proper. Eventually, the New Deal legislation was upheld by one judge of the Supreme Court. There was a court packing agenda. They thought that they will alter
that was the word used, court packing.
By introducing a few more judges there.
10 more judges.
But then what happened ultimately was one judge switched his vote. And that vote which was switched is called in history the switch in time that saved the 9.
Saves the 9. And there are some interesting material on that.
And then they started upholding all the social welfare
It was 3 versus 3. One judge was, my lord, my lord, not clear, and it is my lord, written somewhere. They used to travel. They used to ensure that they travel in the same car and constantly being persuaded, and he remained with the 4. Anyway, my lord, I'll just, my lord, go further. My lord, now please see the last word of Dr. Ambedkar at page Can be skipped. The last concluding remarks of Dr. Ambedkar at page 50. Lord, it starts at page 14, but highlighted part at page 15. I think the language that has been used in the draft, a much more extensive language, which also includes the particular propositions which have been moved by Professor Shah, and I therefore do not see the necessity for substituting these limited particular clauses for the clauses which have been drafted in general language deliberately for a set of purpose. My lord, and the purpose is, my lord, this is, my lord, the emphasis I would very respectfully give. The object and purpose was that it is open for each legislature, depending upon the period of time they are making the economic policies, can have freedom to lay down economic legislations. My lord, complete freedom in joints is given to the parliament. That's the intention.
Yeah.
So, my lord, ultimately, it is left to the parliament. Therefore, a little not vague, but elastic, I would, my lord, put it that way, which can take into consideration the circumstances, factors, global factors, local factors, etc. Now, my lord, I am on page 16. Your lordships need not turn to. What I've said is this. The question, my lords, are deciding is whether a private property can be included under Article 39. What I've said is that when 39 was there, right to property was a fundamental right under Article 31. 19(1)(f), my lord, I'm sorry.
Which page is this in your paper? Page
16. 16. PDF 16.
Yes.
So, my lord, 39B and Article 19(1)(f), that is right to hold and dispose of property, coexisted, meaning thereby 39 always intended even private property. And its deletion now as a fundamental right and it going as Article 300A further strengthens, Lord, that submission that 39B encompasses not just government property. Otherwise, for constitution makers, Lord, there was no reason to say that all property owned and controlled by the government shall be used for general good. Lord, simple. Lord, now, Lord, I have given the statement of objection reasons of 45th Constitution Amendment. I'll skip that, my lords. That may not be relevant, my lord. While going through, my lord, for writing judgment, if your lordship needs, my lord, I have kept everything, my lord, so that your lordships have on one click, my lord, get it. Lord, now please come to Please come to, my lord, page 25. My lord, I have given, again, my lord, for your lordship's assistance. I'm not going to read them, but if your lordships would wish to go through it or, my lord, record it, my lord, in para 24 at page 25, there is one annexure A, where, my lord, I have analyzed the provisions of other constitutions on this aspect. And that is at annexure A, my lord. There is no point reading them. Lord, your lordships can mark its PDF page 72.
Taken from.
Please come to page 30. 30. Lord, para 39, my lord, if your lordships can. So this is what, my lord, I have already, my lord, paraphrased my submission, but this is another paraphrasing. India is a social democracy that aligns closely with the principles of a social welfare state. Social and economic justice is not to be understood in crude terms of distributive justice aimed at a wholesale allocation of the material resources of the community to the people at large in one go. On the contrary, a welfare state means a rationally tailored policy intervention, that is legislative intervention, in furtherance of common good, which may or may not involve compulsory acquisition, ownership and or control of private property. The effectuation of the same is to be carried out in a manner conducive to the common good, thereby achieving socio-economic justice. My lord, I have cited D.S. Nakara, but my lord, your lordships may consider, my lord, for the time being, my lord, not, my lord, read that. Please come to, my lord, page 35. My lord, your lordships are aware, my lord, like which, my lord, we assisted your lordships on the ground of another article where you have to give a declaration that this act is enacted in pursuance to so and so. The same is with 39. The act stipulates, my lord, that we are exercising, the parliament is exercising powers under 39 B or C as the case may be. My lord, I have just, my lord, given a table of several legislations where they have, the parliament has used and mentioned 39B. And, my lord, please see the fourth column, material resource, my lord, which is sought to be regulated or distributed, my lord, under 39B. I'm not reading it. I'll just read, my lord, what are the material resources for which. My lord, Lord, I must add one thing. Lord, this declaration, the way in which, my lord, your lordships have seen, my lord, in other cases, my lord, of alcohol industries, etc., is not mandatory in case of Article 39B. But even if an enactment is not mentioning 39B, the government can defend it on the ground that I seek protection of 39B and therefore 31C. Yes, my lord,
It doesn't say industry, the control of which is declared by
is
Parliament.
declared by the, because the constitution requires a declaration. Here the constitution doesn't require the declaration. my lord, liquefied petroleum gas, crude oil, railway wagons and other goods essential to the need of railways. Then, my lord, 5 components of rolling stock like vacuum brake equipments, ejectors, steam brake valves, etc., etc. Some pharmaceuticals and chemicals, tractors, coke oven plants. Lord, some of them are repealed, some of them are in force, but that's not relevant. I'm just giving an illustration that these are the material resources for which the Parliament did, my lord, take into account and mention 39B. Anglo-French Textile Limited, employing a large labor force. My lord, only one company was taken over, which is still, my lord, in force. That is Anglo-French Textile Limited, acquisition and transfer of textile undertaking. Then handloom and weaving factory.
But where you write the material resources Anglo-French textiles. I wonder what is Anglo-French textiles. Anyway, that's.
It's a limited company, my lord, but
I thought I can say something here.
land, right to use water, Mysore Palace.
For example, a simple thing is the public distribution, where the farmers have to give levy sugar. The farmers have to part with some paddy to the state, so that is taken.
Distributed equally.
Public distribution under
Public
the
distribution, PDS.
essential.
Yes, sir.
See, that is an example, clear, stark example, so close to the people.
I think the
Rationing of food grains.
learned attorney possibly, my lord, wants to say something. If,
No, I was only trying to say about the Anglo-French textiles.
What is that?
I appeared in that matter way back in 1984. And that was a textile mill which is lying closed in Pondicherry for about 3 years. After this honorable court intervened, then the government set up a Pondicherry Textile Corporation. That's how it was taken over. And it was a private industry.
Oh. All right. Yes, Mr. Valista.
Lord,
What
then
next?
please come to, my lord, I have given 23 examples.
Yes.
This may not be exhaustive. We have tried our best to be, my lord, as exhaustive as possible. There may be some, my lord, legislations left, but public transport system, etc., etc. Lord, now kindly come to, my lord, PDF 38, para 47. Where, my lord, this honorable bench, my lord, permitted placing of reliance under 39B while defending a particular challenge to an enactment. That is Bhim Singh ji, my lord, her ladyship, my lord, mentioned.
Case where there is a change in the mindset. 1976 Urban Land Ceiling Act came, and in 1999 it was repealed. That is during the times of 1999 post-liberalization.
Correct.
So 1976 and 1999, that is a stark example of how there is a evolving economic democracy
Yes.
in the country.
Depending upon several internal and external factors. And when I say external means global market, internal factor means, my lord, the production decreasing or increasing, the demand being less or more, etc., etc.
All right.
Lord, I'll just read the highlighted part of Bhim Singh ji, where urban land ceiling laws were under challenge. The whole story, my lord, just above, my lord, just before the highlighted part, the whole story of the legislation, the long gestation of pre-legislative consideration, the brooding presence of Article 39B and C, and the emphasis in Section 23(4) on common good as the guiding factor for distribution point to public purpose, national development and social justice as the cornerstone of the policy of distribution, it is not and never can be compulsory taking from some private owners to favor by transfer other private owners. Lord, thereafter, my lord, this is all, my lord, last line, last passage, my lord, at page 39. I have already indicated that the postulate underlying the directive principles of Article 39B is that diffusion of ownership and control of material resources of the community is always in public interest, and therefore The state is directed to ensure such distribution equitable thereof as best to subserve the common good, but the priorities prescribed in subsection 1 and 4 of section 23 in regard to distribution of material resources produce contrary results as or results in the opposite direction, inasmuch as private purposes receive precedence over common good. My lord, that is more on the act, my lord. Then, my lord, there is one, my lord, this judgment is, my lord, very Tinsukia electricity, where electricity under 39B was taken under the control of the government. Come to justice, Lord, there are other judgments where 39B is considered, my lord, for the purpose of testing the validity of a particular legislation, my lord. Now your lordships can consider, my lord, directly coming to 48. My lord, I have given all those judgments where 39B is considered, my lord, but broadly, the view, my lord, which your lordships have taken is this, my lord, that ultimately it must evolve. It has to be left to the parliament, because the parliament is the best judge to decide under present circumstances how the economic growth will take place, whether a particular mode or a particular my lord, format is a better suited format or not. Lord, page 48, Lord, Coal India, my lord, it is judgment, my lord, by 3 honorable judges, my lord, authored by Justice K.M. Joseph, a very recent judgment, of which, my lord, her ladyship Justice Nagaratna was also, my lord, a part of the bench, where Coal Mines Nationalization Act was considered. Lord, the issue was whether this act would, the Competition Act would apply to Coal India or not in view of Coal India, Coal Mines Nationalization Act. Well, please see, my lord, the underlined portion. Well, this is per Justice Joseph, my lord.
Which para you are reading?
Lord, para 97, page 48,
97.
para 57 of my note,
97 of the judgment.
97 of the judgment.
Para 57 of your note.
Yes, my lord. Recently, my lord, it starts with that. Recently, the lordship gets me. My lord, Justice Roy gets me.
Yes, yes.
Recently, a 3-judge bench in Coal India Limited versus CCI, that is Competition Commission of India, in the context of applicability of Competition Act to Coal India, which was created under the Coal Mines Nationalization Act, it was hailed as under. The appellants are government companies. They were brought into being in the context of Section 3 and 5 of Nationalization Act. Undoubtedly, they were created to take the place of central government in the matter of supervising, control, and managing the affairs of the mines. Still further, and more importantly, the Nationalization Act itself was intended to achieve the goals in Article 39B of the Constitution. This means that the Nationalization Act contemplated coal to be a material resource, and it was to be distributed so as to subserve common good. The exclusive right in regard to the mines, as also the power to manage and supervise the mines, was vested with the first appellant company and its subsidiaries. The ambit of the power is unquestionably wide. We proceed on the basis that the appellants cannot be oblivious to its duty to bear in mind the sublime goal in directive principles, that is distribution, so as to subserve the common good. Lord, please come to, my lord, next, my lord, page 49, para 100 of the judgment. Does your lord, am I with your lordship? The expression common good in Article 39B is a Benthamite sense, involves achieving the highest good of the maximum number of people. The meaning of the words common good may depend upon the times, the felt necessities, the direction that the nation wishes to take in future, the socio-economic condition of the different classes, the legal and fundamental rights, and also the directive principles themselves. As far as the time dictated content of common good goes, it simply means that economics itself not being bound in chains, but it is a dynamic concept. This, my lord, evolution will be, my lord, with the parliament. Then, my lord, the attainment of common good would be dependent on the appreciation and understanding of a generation as to how economic common good is best achieved. The debate between advantages and disadvantages of pursuing the policy of the state intervention in economic policy which emasculates private enterprise and competition has almost reached its end. The advantages of a fearlessly competitive economy have been realized by the nation. There is a backdrop to it. In the year 1991, as ladyship was saying, the nation was in a manner of speaking compelled to revisit its economic policy, having regard to the precarious condition of its foreign exchange reserves. The Permit Raj, which involved acute regulation of economic activity by the state with all its attendant evils, cried out for reforms. A slew of highly liberal reforms in 91 set the stage of the nation to make paradigm shift. As discussed in Raghavan Committee report, things moved further in the direction of attaining faster economic growth. The Act is a measure which is intended to achieve the same. The role which was envisaged for the public sector company could not permit them to outlive their utility or abuse their unique position. Disinvestment done in a proper manner was perceived as a solution. However, sans disinvestment, state monopolies, public sector companies, and government companies were expected to imbibe the new economic philosophy. The novel idea which permeates the Act would stand frustrated. In fact, if state monopolies, government companies, and public sector units are left free to contravene the law, your lordships cannot skip. Kindly come to 120. We agree with the appellants, and as held by this court in state of Karnataka versus Raghunath Reddy, Lord, judgment which is placed, Ranganath Reddy, my lord, which is placed for your lordship's consideration, that distribution is a word of wide meaning and it is covered by Article 39B of the Constitution. It must be remembered that court had occasion to hold so by way of dealing with the argument that nationalization did not have a nexus with the word distribution. Now, my lords, may kindly come to page 51. Lord, the argument was, I'll just paraphrase my submission, my lord. The argument of the other side was, that was more in the context of Mahada, that preservation of buildings or preservation of natural resources can never be a part of Article 39B. My lord, which, my lord, I have dealt with saying,
Yes.
that intergenerational equity is a concept accepted by our jurisprudence. We preserve many things for the next generation. That is, my lord, what we call intergenerational equity. Please see, my lord, page 51, para 59.
That phrase has been used in this judgment? What
No.
you're saying?
No, not in this judgment. But there are several judgments where intergenerational equity, word, my lord, I'll place it for your lordship's consideration. But that's an accepted position under Indian jurisprudence, that this generation protects and preserves as a trust for the next generation. Yes. Forest, land, natural resources, minerals, etc., etc. And also intergenerational equity is used. But I'll place, my lord, those judgments while highlighting that part. 60. The purpose behind Article 39B, my lord, I'm reading 60, is to secure the ownership and control of a resource in order to distribute it in a manner which results in common good. The argument of the petitioner, therefore, is that preservation of a resource does not amount to common good. Apart from the fact that the said argument is unsustainable owing to the natural wide meaning of the term common good, preservation of any resource is often required in order to further the common good for the people at large and the nation as a whole. For example, the new entrenched principle of intergenerational equity propounded by this Honorable Court in the context of natural resources provides that resources need to be judicially used in order to ensure that future generations are able to enjoy the fruits of the same. Intergenerational equity requires, in a welfare society and a society based on egalitarian principles, preserving resources, even though they are privately owned, for the common good of the future generations. The constitutional principle of egalitarianism requires that intergenerational equity is adhered to. A balance is required to be struck. Within 63. Intergenerational equity thus requires that present generation utilizes. Lord, that's more repetition. I can skip that one. Lord, I have cited, my Lord, two judgments on intergenerational equity. One is state of Himachal Pradesh versus Ganesh Wood Products, and another, my Lord, as my learned friend, my Lord, Mr. Dwivedi, the younger younger Dwivedi pointed out, my Lord, Eklavya, para 65, T.N. Godavarman. Mr. Eklavya, he is also younger Dwivedi, my Lord, but Lord, then consistent precedents on the issue without any conflict. Lord, I will not read it. Your Lordships were, Lord, taken through all the judgments where the definition or the interpretation of 39B, which we seek to give respectfully, has been accepted, my Lord, be it Ranganatha Reddy or, my Lord, Abu Kavur Bhai, etc., etc. Or, my Lord, my last point now.
Yes.
Lord, I have already, my Lord, respectfully said that the views of Justice Krishna Iyer may perhaps not be relevant, my Lord, in the present context. I would put it that way, my Lord. And I very respectfully, while respecting the judgment and the view, Lord, respectfully seek to disagree.
You or some of it?
The sum of them, my Lord, it's no, not entirely. I have
That
too
will be
small
contrary
to
to your argument.
disagree with Justice Krishna Iyer in the entire.
I hate Sangaratari.
But it was otherwise also contextual. It was in the context of the private property involved in that case, but the discussion became very wide and over-encompassing, my Lord, which may.
He said that we are not to be construed as having accepted this line of
Correct.
this line of
Correct.
analysis.
And that was in a concurring judgment.
Concurring.
All that was said.
Yes. Lord, page 62. Lord, and this is my last submission on 39B. Lord, my respectful submission is that Mafatlal Industries is not an arbiter. And Lord, I raised that point very seriously. Lord, this is a judgment delivered by 9 honorable judges.
Are you touching?
Lord, page 62, PDF 62. And I have quoted the relevant paragraphs.
Mafatlal, there is only mention in one paragraph.
72.
Ah, that's it.
My 72, my Lord.
Your 72. In Mafatlal also it is in one paragraph.
No, Lord, that's what is not pointed out. But that's what I want to point out. And my Lord, my respectful submission at the cost of repetition, it is not an arbiter. It is a ratio decidendi. My Lord, I would urge your Lordships to bear 3 factors in mind when a judgment can be said to be arbiter. A, whether the question decided arose for consideration. B, whether arguments were advanced by both the sides. And C, whether the court dealt with cursorily as a passing remark or while dealing with a specific submission made by the council. Lord, here, not only the lead judgment, even concurring and dissenting judgment is also, my lord, answering this question. Something which is not, my lord, brought to your lordship's notice. A specific argument was raised by Mr. Parasaran. And from the reading your lordship's, my lord, in my respectful submission will find that in fact court wanted it to become a ratio decidendi. Your lordships have page 62.
Yes.
My para 72 and
Yes.
judgment para 84. My lord, kindly allow me to read this one because I want to show point was specifically raised. In this connection, Sri K. Parasaran has rightly emphasized the distinction between the constitutional values obtaining in countries like United States of America, Canada, and Australia, or for that matter, United Kingdom, and the values obtaining under our constitution. This discussion, we may reiterate, is also relevant on the nature of the constitutional right to refund or restitution, as it is called. That was the question, my lord, in Mafatla, flowing from Article 265, referred to in para 71 to 73. Unlike the economically neutral, if not pro-capitalist, constitutions governing those countries, the Indian Constitution has set before itself the goal of justice, social, economic, and political, a total restructuring of our society. The goal being what is set out in Part 4 of the Constitution, and in particular in Article 38 and 39. Indeed, the aforesaid words in the preamble constitute the motto of our Constitution, if we can call it one. Article 38 enjoins upon the state to strive to promote the welfare of the people by securing and protecting as effectively as it may a social order in which justice, social, economic, and political shall inform all the institutions of the national life. Article 39 lays down the principles of policy to be followed by the state. It says that the state shall in particular direct its policy towards securing, b, that the ownership and control of the material resources of the community are so distributed as best to subserve the common good, and c, that the operation of the economic system does not result in concentration of wealth and means of production to the common detriment. Refunding the duty paid by a manufacturer or SSE in situations where he himself has not suffered any loss or prejudice is no economic justice. It is very negation of economic justice. By doing so, the state would be conferring an unearned and unjustifiable windfall upon the manufacturing community, thereby contributing to concentration of wealth in a small class of persons, which may not be consistent with the common good. The preamble and the aforesaid articles do demand that where a duty cannot be refunded to the real person who have borne the burden for one or the other reason, it is but appropriate that the said amounts are retained by the state for being used for public good. Indeed, even in an economically neutral constitution like the United States of America, such a course has been adopted by the state and upheld by the courts. It would be rather curious, nay, ridiculous, if such a course were held to be bad under our constitution, which speaks of economic and distributive justice, opposes concentration of wealth in few hands, and when a 42nd amendment describes our republic as a socialist republic. Lord, please come to, my lord, at the foot, para 86, that the material resources of the community. Now, my lord, kindly see, they discuss it specifically. 39B is discussed, not as a passing remark. In the first para, the learned judges say this is relevant even for deciding the question of refund. Then they say in para 86, that the material resources of the community are not confined to public resources, but include all resources, natural and man-made, public and privately owned, is repeatedly affirmed by this court, Sri Ranganatha Reddy, etc., etc., etc. Now, my lord, may kindly see para 73. Justice Paripurnan's concurring opinion. Lord, an obiter dicta, in my respectful submission, would be in one judgment. If it is also discussed, a point is also discussed and deliberated and adjudicated upon, even in the concurring judgment, Lord, it can never be an obiter dicta. Obiter dicta is just something said in passing. The question never arose, arguments not made, court never intended to decide that point, and as a passing said something. Here, my lord, after reading the majority, I am, my lord, reading the concurring view of Justice Paripurna. Lord, please see at the foot of page 64. Lord, just, my lord, for 10, 5, 7 line, my lord, from the underlined portion, Sri K. Parasaran, my lord, your lordship gets, my lord. My lord, Justice Paripurnan also is pleased to note the contention of Mr. Parasaran. Sri K. Parasaran brought to our notice the following portion of the preamble and Article 39B and C of the Constitution to contend that Article 265 of the Constitution cannot be construed in a vacuum or isolation, but should be construed in light of the basic principles contained in other parts of the Constitution.
We got the point that you are saying that it was also dealt with by Justice Paripurnan. What happened was, the question was whether if a tax is struck down or if the levy has been held to be illegal, whether there should be a refund. The court said that, look, the manufacturers have not, they've passed on the burden.
Yes,
they are pertinent, and therefore it will result in unjust enrichment. And therefore, on the one hand, if you say that, well, the manufacturers will be entitled to a refund, all these resources will go into the hands of the manufacturers and promote a concentration of wealth. On the other hand, these resources could be used by the state for the purpose of the common good. And therefore, they said Article 39.
Material resources for the community, stressing it from 39B. Now, my lord, what is not quoted, but I must bring to your lordship's notice, there is a minority view in Mafat Lal judgment, my lord. Please have a look at, my lord, volume.
Just give us that, we'll just make a note of it and
Yes,
take your word for it.
My lord, volume 5.
Whose minority view is that?
Justice Sen, my lord.
All right. So volume 5 page.
Volume 5, relevant is, my lord, at page 2914, paragraph 161.
That's all right. We'll take it that.
There also,
also
contention noted and dealt. So, my lord, my respectful submission is, Lord, there is no need, my lord, for my lord, the bench, my lord, sitting in the combination of 9 honorable judges, my lord, to revisit that point, unless it is, my lord, referred to a still larger bench. My lord, last.
Nothing to do with 39B.
My lord, now, my lord, I will come to my lord, this is the submission on 39B. Now, my lord, I would wish to assist your lordships on the question of 31C, my lord, according to them, that goes. It's a dead letter. My lord, since that was raised, my lord, subsequently, my note is, my lord, subsequent, my lord, that is 2L. Two capital L.
Two capital L.
L for London. Just for ease of reference.
It's like the vacation is in your mind, solicitor.
Why, Manoj? No. Your lordships are right, my lord. I could have thought of some, my lord, state, my lord, in India.
L for Lakshadweep.
Yes, my lord, nothing, my lord, in the contextually, well, L for Lakshadweep, not for London. Lord, Lord, for the ease of my lord reference, I have taken the liberty of giving different color to 31C. Lord, first part, which is blue in color, and second part, which is red in color. Correct, Manoj? Please see the red part, because this is what is
Red was struck down in Keshwan.
in Keshwanand. That's all, Manoj. Manoj, one more thing. Manoj, I can place it on record, and I do wish to place it on record. Lord, so far as validity of 31C, except the red part is concerned, in Keshwanand Bharti, all 8 honorable judges unequivocally upholds it with separate reasons. And I would, my lord, each para I would quote and place it for your lordship's consideration. My lord, the general discussion, my lord, which happened, this is not my argument, my lord, just by way of, my lord, reference, that in Keshwanand Bharti judgment, who decides what and what is ultimately ratio for what proposition, my lord, is not a criticism or a discussion qua 31C. 31C, the bench is very clear. 8 honorable judges unequivocally, with reasons, uphold the validity.
Yes.
Now, your lordship, my lord, kindly see. It is, my lord, now amended, page para 4. Just, my lord, since few days have passed, my lord, just to refresh your lordship's memory, and there is
all or any principles enshrined in part
yes,
4.
yes, my lord, that is para 4. But, my lord, I would like to again read, my lord, para 4, my lord. 42nd Amendment, see, this is section 4 of the Constitution Amendment Act. Correct, my lord? Please bear that in mind, because my submission is going to be that this amending section has gone. 31C was never under challenge. And if the view propounded by them is accepted by the court, what will be the devastating consequence? I have given illustrations. Lord, for example, tomorrow, one word from the preamble is deleted by way of a constitutional amendment. That constitutional amendment is challenged, and your lordship set aside that amendment that you could not have deleted. Economic justice, for example. Would the entire preamble go? That's the argument, my lord. It sounds absurd, but it is that absurd, and I'll show that.
Your argument was language is now meaningless.
It becomes completely meaningless.
Yes.
And I have quoted that language, that now, if they are right, how 31C would read.
Meaningless totally.
It becomes meaningless.
No, section 4, the amendment of Constitutional Amendment Act, section 4. That section 4 is inserted into the main section, Article 31C. It is inserted.
Substituted.
Yes. So it becomes part of Article 31C. It does not have an independent existence.
Correct.
Maybe by a Constitutional Amendment Act, but ultimately it goes into the main Article 31C.
Correct. So now what was included now no longer exists.
Yes.
And what was there in law has to exist. My lord, that is my respectful submission. Now, my lords may kindly see, Lord, this was challenged, and Lord, first.
So according to you, once section 4, the 42nd Amendment is struck down, that necessarily results in the restoration of the position as it existed on the date of the adoption of that provision.
And one more thing, my lord, why? To buttress my submission. Lord, my Lord Justice Y.V. Chandrachud upheld the validity of 31C. My Lord Justice Y.V. Chandrachud authored the judgment of Vaman Rao, which challenged the original 31C. But simultaneously, the bench presided by my Lord Justice Chandrachud, who also happened to be authoring judgment in Minerva, I'll show that, was considering post-amendment 31C. So there were two matters simultaneously going on. Vaman Rao, 31C, as upheld by Keshwanand Bharati. Second, Minerva Mills, 31C, as amended by 42nd Amendment. Both judgments delivered by my Lord Justice Y.V. Chandrachud. And therefore, my Lord, I'll show there is a clear intention of the court. Court is conscious that this is what will be the effect of our judgment, that what was upheld by Keshwanand Bharati now stands revived.
Clear.
Have they said so?
His lordship, pardon? Yes, my lord. My lord, if your lordships are,
You concluded because your second point, no?
this is my second.
So if you can just take us briefly through
Lord,
it.
I'll just
Get
take
the
a
other
lordship
side.
through it,
Then
my
Mr. Dwivedi will take it.
Without, my lord, reading.
So according to you, Vaman Rao was dealing with the unamended 31.
Unamended
That's
31.
your contention.
There is no dispute on that. Minerva was dealing with Section 4 of amended, Section 4 as amended by 42nd Amendment. Both decided by same learned Honorable Chief Justice, my lord, who was the only factor common with Keshwanand Bharati also.
But did Vaman Rao deal with the unamended section 31C in respect of a period after
The amendment.
the striking down of the amended 31C?
Yes, yes, my lord.
Or was it dealing with a period prior thereto?
No, after. And therefore it says that what will...
Prior.
No. Kindly have a look at, my lord, kindly have a look at it.
Anyway, we just think, bear it in mind. We don't, you can go in your own way and then
Judgment came
come back to
substantial.
My lord, the writ petition was 77. But please come to, my lord, page 6, para 6, my lord, page 3.
What's your formulation, Mr. Solicitor, on this?
My lord, my formulation is, my lord, can I show and formulate?
Sure.
Can
You
I
can
show
just
and
quickly,
formulate?
yeah, that's right.
My lord, page 6, my lord, para 6, page 3.
Page 6.
Para 6, my lord, page 3, para 6.
Yeah.
My lord, again, I'm sorry, my lord, but the same learned Chief Justice,
Yeah.
Lord Justice Y.V. Chandrachud. Why I, Lord, refer to the name, the purpose is that his lordship was aware that I have dealt with one 31C challenge at 30 as a combination of 13 judges. Vaman Rao is 5 judges, unamended. And now I have also heard Minerva Mills, which is post-amendment. And therefore, my lord, in that context, please read his lordship's word. My lord, para 4. In these proceedings, the main challenge now is to the constitutionality of Article 31A, 31B, and unamended Article 31C of the Constitution. Now, my lord, kindly see last line on page 3. We are concerned with Article 31C as it stood originally but of course without the concluding part struck down in Keshwanand Bharati. So his lordships were dealing with the first part because second part was struck down by in Keshwanand Bharati. Now, my lord, para 7. Again, my lord, in Vaman Rao, my lord, the learned Chief Justice says, 52. That leaves for consideration the challenge to the constitutional validity of unamended Article 31C. As we have stated at the beginning of this judgment, Article 31C was introduced by Constitution 25th Amendment. Initially, it sought to give protection to those laws, your lordship can skip,
This is again Vaman Rao, no? This quotation.
This is Vaman Rao. Then 53. Mr. M.N. Phadke, who led the argument on behalf of the petitioners, built a formidable attack against the vires of Article 31C. But with respect to the learned counsel, the effort is fruitless because the question as regards the validity of Article 31C is no longer res integra. The opening clause of Article 31C.
What was the law in question in Vaman Rao? That was the Maharashtra Agricultural Ceilings Act?
Yes,
Maharashtra,
agricultural tenancy or see.
there were 32, Article 32 petitions, my lord.
It was the agricultural holding.
Agricultural land, within brackets, Sealing and Holdings Act, 1961. But his lordship decided.
Had to be decided on the basis of the unamended Article 31.
Correct. Therefore,
Because on the date when that law was enacted, unamended Article 31, bench did was, they tested the validity of the law with reference to unamended Article 31C. It was not a post-Minerva Mills legislation.
it was not.
Ah,
It was not.
we
It
may
was
still-
pre-Minerva
still
Mills.
come to the same conclusion, but we must have conceptual clarity that Vaman Rao was basically dealing with and clearly an unamended Article 31C.
It says so.
So Vaman Rao may not have a bearing on the residue of Article 31C which remains post the decision in Minerva. Vaman Rao may not really be conclusive. We will have to address it as a matter of
My lord,
first principle.
My lord, it would have a bearing for the simple reason that both Vaman Rao and Minerva Mills were heard together and decided by the same learned judge.
That militates against your submission because it's very clear that in Vaman Rao, they were not considering the impact of what will remain after 31C as amended by the 42nd Amendment is struck down. They were not considering that at all. As to whether there would be a revival, whether that would, as a matter of first principle, we may still come to that conclusion, but Vaman Rao does not give us a conclusive guidance on that.
Correct, my lord, but
Doesn't relate to that
It
period.
doesn't relate to the period at all, which we are now dealing with here.
But my lord, kindly, my lord, come to the last part, para 54, because his lordship also deals with 31C on a different ground and upholds it. I understand what is falling from your lordship, my lord, the Chief
I
Justice.
think the substantive answer which you have to the argument of the other side should be something like this. The original provision of 31C, which granted protection or immunity to laws against a challenge, so long as that law implements 39B and C, that original provision was upheld in Keshwanand Bharati, except for giving finality to the declaration.
Judicial review was over.
Judicial review was saved. Now, the widening of the ambit takes place in the 42nd Amendment. When Parliament widened the ambit, the idea was never to replace what was the original content of 31C with a completely new provision, but to expand the ambit to include 31, 39B and C plus all the other provisions. What was held to be objectionable in Minerva Mills was not the original ambit of 31C, but the extension, because they could not have said that the original 31C was invalid for the reason that they were bound by Keshwanand Bharati, which they also express. So essentially, according to you, what was struck down was this unlimited power which was given, expansion of 31C to include not merely 39B and C, but the entirety of Part 4 of the Constitution, because the court said then every law which can be sustained on the ground that it implements some provision of the directive principles or the other.
Correct.
So when Minerva Mills strikes down Section 4, you must read the intent of Parliament and the intent of the court. The intent of the court is not to strike down the entirety of 31C.
It was not under challenge.
But the
Only
intent
Section
was
4 was under
expansion. Now, therefore, to hold according to you that look, even the original 31C is therefore completely obliterated by virtue of the substitution by section 4 would be in that sense a very formalistic reading of the Constitution.
Another point, my lord,
We are on, is there a more, other than saying it's a formalistic reading of the Constitution, is there a constitutional concept which we
Concept.
can, is there at a conceptual level, can we not?
may I, my lord, assist your lordship on that?
Doctrine of revival applies.
It would not be necessary, my lord, there would not be revival necessary at all. I'll tell your lordship why. Your lordships are aware of the Blackstone doctrine, which is accepted in India by Golaknath downwards. But Blackstone doctrine says that your lordships do not declare the law, your lordships merely validate or invalidate the law. Lord, kindly give me a minute more, my lord, to formulate my submission. Lord, suppose today Parliament amends the law by amending Act number so and so. Section 2 of the amending act amends the law or the Constitution. The principle governing this both, my lord, would be same. After 2 years, your lordships were to strike it down. That no, this is unconstitutional. Right? I'll read, my lord, that passage from Golaknath judgment, where Blackstone doctrine, my lord, is followed. What your lordships would be doing is, your lordships would be declaring it to be invalid from the date of its inception. It never was born. When your lordship says in Minerva that section 4 of the amending act is unconstitutional, that substitution goes, meaning thereby the original 31C was always there. That is your declaration, your lordship's declaration. That is, my lord, Blackstone doctrine and accepted in India. It would remain on the statute book.
That's his argument. That what would remain on the statute book? Mr. Andarjana's argument is
31C as it.
No, his argument is what remains on the statute book is 31C as amended. But it is held to be inoperable or unenforceable.
If your lordship sees, my lord,
And
Blackstone.
if it remains on the statute book, according to him, if it remains on the statute book but is rendered unenforceable, then you cannot have another provision to the contrary on the statute book, which your argument would entail. That's the
If your lordships are, my lord, not going into this question, my lord, but there is one more point.
The better way of perhaps looking at it is this: that what was the parliamentary intent in its constituent capacity? The parliamentary intent was not to delete Article 39B and C from the ambit of the amended 31C. The object was to continue with 39B and C.
And then expand it.
And then expand the ambit, right? The original provision was upheld in Keshwanand Bharati. Now, the purpose of Parliament in the 42nd Amendment not being to delete the reference to 39B and C, but to expand the ambit of Article 31C, the declaration of unconstitutionality of Section 4
She put it on the group.
reach out to 39B and C, but those principles of Part 4 other than 39C.
Yes.
Right? And therefore, when Section 30, we may then be able to skirt this whole issue of revival and other things.
Yes.
By looking at this particular factual context, this particular constitutional context, because you have to look at that constitutional concept, constitutional concept and perspective.
But when
This is not capable of easy resolution. That's why we are 9 of us looking at it here.
Yes.
If it was so simple, we wouldn't be here assembling in
My lord, there is, my lord, a judgment
since
solicitor, Mr.
Madam.
Andarjana's argument was that the power to repeal a provision is a power which is exclusively entrusted to the legislature. It is not a power which is conferred to the court. And the court cannot, therefore, when it strikes down, do something which is really a power of the legislature. The legislature can always say, all right, instead of all or any of the principles, we substituted with the word Articles 39B and C. That's the power of the legislature. You as a court don't have the power to do that. You can only declare that this is null and void and therefore of no enforceability whatsoever. That is the argument. How would you deal with that argument?
Lord, would it apply? Lord, I'm posing a question to myself. Yeah, what? I think we go to.
I think
Formulate it. What is your point so that then we'll
Yes,
wrap up?
Lord,
We'd
before
like
that,
to hear a little more submissions on this. We've got your point, but how would you then put it together in?
Yeah. Lord, before that, before I formulate, can I only show one paragraph in Minerva? Lord, can I show one? I'm sorry. Lord, Lord, in Minerva Mills,
but in Norman law also they could.
In Minerva Mills, please see, my lord, page 7, only read portion
Of your note?
of my note. Page 7, the I'll be as fast as I can, my lord. Only read portion your lordship has, my lord?
Yes.
My lord, while comparing the old and the amended, the same learned judge who decided all three, who was a part of all three and, my lord, author of the two, the question for consideration in light of this position is whether Section 4 of the 42nd Amendment has brought about a result which is basically and fundamentally different from the one arising under the unamended article. If the amendment does not bring about any such result, its validity shall have to be upheld for the same reasons for which the validity of unamended article was upheld. And thereafter, my lord, the learned judge, my lord, is pleased to say that no, it gives a different result. My lord, therefore, my formulation is this. My lord, the principles of interpretation in case of a statute and the constitution would be different.
Yes.
Second, the parliament, while amending 39B, 13(1)(c), never intended to delete or obliterate 39B and C.
Yes.
Therefore, when
Third,
it merely expanded the protection under Article 39 B and C to entire Part 4.
fourth,
But what was found fault with was the expansion and not Article 39B and C.
found fault with in Minerva was
And therefore, the moment Minerva judgment comes, the expansion goes. And not the original 31C. Fifth, my lord. Sixth, my lord. The learned judge, my lord, who decided Vaman Rao, and who possibly, my lord, was also in the process of dictating or deciding Minerva, makes a positive declaration, my lord, which is not under challenge.
I think in one part of your statement, you are wrong. What I understand is that those days, the judges used to write by hand instead of giving dictation. In fact, copious pages were written so far as the judgments were prepared. So remarkable fortitude and effort that was taken.
Possibly, therefore, the judgments were also not
Precise.
very long and precise. Lord, please come to that declaration, para 9,
That we have seen
para
at
16,
the end of Minerva.
para 16.
In other words, you're saying Vaman Rao, which came later, has to be read alongside with Minerva Mills.
Because it happens to be decided by the same bench, well, only by even
There
bench
is a
were,
there is a judicial, what you say, a statement made.
declaration made. It says, Malad, the declaration says in Minerva Mills that 31C, as upheld in Keshwanand Bharati, stands and only the amended part goes. It could not have been more elaborate or clear or unambiguous than this.
And because it has been upheld, Kanan Bharti.
It
Yes.
could not have been, Malad. Can never be. I'm obliged. That's going to be the submission. Lord, in a statute, there is a possibility of a void being created. But in constitution, there cannot be any constitutional void unless the court is dealing with validity of a constitutional provision which is declared unconstitutional. Lord, there is 31C is not under challenge in Minerva. Well, let us be very clear. Only section 4 of the amending act was challenged.
Right. And that's
Lord,
it, Mr. Now.
Only 5 minutes, my lord. And my lord, there is one judgment. I'll not read, my lord.
Which one is that?
Lord, that is on what happens when there are several legislative devices for the purpose of amendment. It can be by addition, deletion, substitution. What happens when the legislature chooses the design of substitution? And the Supreme Court has said, my lord, at page 10, para 23, this is my lord last judgment, I'll cite. What happens to substitute? I'll not, my lord, read. Your lordships may, my lord, read it, but it's very, my lord, illustrative, and my lord, it would assist your lordships. That if it is substituted and substitution is held invalid, the original remains. Examples on the well, last 5 minutes, my lord, give me last 5 minutes. Lord, please come to page 14. My lord, if your lordship takes the view which the other side, my lord, is arguing, Lord, page 14. Lord, what will be the anomalous situation in a constitution, which is the document of governance of the nation? Lord, I have given some examples. For example, Lord, I have what we have done. The cases where constitutional amendment came by way of substitution. By way of substitution. Suppose that substitution is challenged and that substitution is upheld. Lord, what will be the struck down? What will be the anomalous situation? Please come to page 14. Lord, amendment in the preamble came by 42nd Amendment by way of a substitution. Suppose that would have been struck down, the entire preamble goes by their logic. If their logic is true.
Substituted sovereign democratic republic with sovereign socialist secular democracy.
Substitute, they added.
But the amending act, no, Lord, amending act says substituted. Same language as for section 4. It is substituted, my lords.
Substituted the word. They didn't say add socialist secular after sovereign and before democratic.
No,
They substituted.
Page 3966, it's on record.
No, we got it here.
Yes, volume 4, 3966.
The footnote in Mr. Shankarnaran's.
Yeah, yes. No. So the entire preamble goes by their logic. Now, my lord,
No,
amendment.
that is
not
not
the
their,
entire
that is
preamble.
not the import of their argument.
No, my lord, but that line goes, my lord,
Everything goes in.
that is,
Everything goes.
then your lordships are right.
Right, everything. goes.
Literally everything goes, my lord, if their argument is accepted. My lord, I'm sorry, my lord, for giving this illustration. My lord, giving this illustration, the salaries of judges are also by way of amendment by substitution. There cannot be a constitutional vacuum. There can be a statutory vacuum. That's the contention.
The word.
I mean, in another way, sorry.
Earlier it was sovereign democratic republic. Now socialist and secular were added between sovereign and democratic.
Substitute. So the amending act uses.
But we are taking out this word and we are putting this. And it's 42nd Amendment.
Correct, my lord, but I am on substitution, my lord, that if it is substituted part goes. Suppose your lordships were to accept the challenge to those new additions, then only substituted part goes, the entire part doesn't go.
Why it is second part directly affects us because that deals with our salaries.
Well, therefore I say kindly pardon me for this example, but salaries are always, my lord, amended by way of substitution. So there would be a vacuum, my lord. My lord, there can be a statutory vacuum. There cannot be a constitutional vacuum. So that's the respectful.
But please rest assured, if you increase the salary, we will not strike it down.
No.
And it cannot be decreased.
No, we'll.
And it cannot be decreased. Service condition 284 shall be substituted.
No, that's all. And 4 and 2 are perimateria. And now, Lord, only last line, Lord, para 20. Please see page 20. How section 31C would look like or would exist if their argument is right. Para page 20. Saving of laws, my lord, your lordship gets, my lord.
Those all or any of the principles will go completely. It will.
Notwithstanding anything contained in so and so, no law giving effect to the policy of the state towards securing blank, blank, blank shall be deemed to be void.
No, according to Mr. Andarina, those words will still remain on the statute book, but they will be unenforceable.
My lord,
They don't go. That's the argument.
How do we reconcile, my lord, a preamble and large number of substitutions? My lord, there are some inclusions also. By way of amendment, something is included. But we have examined the substitutions. And please examine, my lord, if that, my lord, kindly, my lord, your lordships are aware, my lord, when privy purses were taken away. Privy purses were taken away by way of a constitutional amendment. Because constitution promised that we would be giving these privy purses. My lord, they failed. But suppose they would have succeeded. Kindly, my lord, examine. This is a, my lord, glaring. I'm sorry, my lord. My lord, this is my last example, but a glaring example. After, my lord,
By and large, we got
only last example, which I feel, my lord, is a glaring. My lord, this argument would put the court in a little helpless position. That's what I want to show. That's what I want to show. Therefore, this interpretation should be avoided. My lord, in original constitution, there was a my lord, article which gave certain assurances to the princely states by way of princely purses. My lord, the government of the day decided that we should do away with princely purses, princely purses, privy purses. My lord, that is Article 360, whatever. My lord, that deletion was challenged. Correct? Deletion was challenged. Ultimately, the challenge failed. But suppose the challenge would have been allowed by your lordships.
was allowed. Because it was by order.
By order, it was
They said
executed.
that these rulers will be derecognized. That's why they said you can't do it. Then
But
Parliament
you can't do it
upheld.
You can't do it in an executive action.
Well, just the
Raghunath
election
Rao,
was-
Raghunath
just the
Rao.
election
But
was-
thereafter, the court said first that you can't do it by an executive order, you have to have a constitutional amendment. Now, please see, my lord, suppose that challenge would have been successful. The article goes, your lordships cannot enact the law. That letter would remain that they would get privy purses. If somebody were to come before your lordship will have to say, if they are right, that sorry, we have struck down the deletion, but we can't do anything unless the parliament re-enacts. But that cannot be the intention.
Thank
So,
you.
Mr. Salve wanted to say something because he appeared in both Vaman Rao and
Mr.
Minerva
Salve?
Mills, if your lordships can.
Yes. My lord, I just want 10 minutes, my lord, and I'll finish at lunch. By the clock.
Before my learned friend starts, just one small interjection, Claude will permit me.
Mr. Attorney will come back to you after lunch because Mr. Salve only wants 10 minutes. So that
No, fair enough. I thought after lunch I may have some. I just want to say I prepared a note.
All right.
Yeah, I'm not going to ask you to read that note. That note is on first principles and entirely addressing this question of revival. So I just want to say you lot kindly read that. Probably some light may be available in that note.
Just ask your junior to give us the volume number for your note. So
I
we
will
can-
do that. I'll do that. I'll do that.
Yes, line, my lord. The judgment in Minerva and Vaman Rao was delivered on the same day.
9th May 80. 9th May 80.
No, my lord, I
Two.
just wanted to add two things.
Yes, Mr. Salve.
My lord, the fallacy lies in
Operative
applying-
order.
Operative portion.
Operative.
Yes, yes, operative one. My lord, the fallacy lies in applying rules of statutory interpretation to reading judgments of the court, molding relief in constitutional matters. My lord, Article 368's construction that there is a limit on the power of Parliament to amend the Constitution is one of the most perhaps dramatic developments of constitutional law jurisprudence in the world. How that power is exercised and what is the consequence of that power, only your lordships can say. So reading rules of substitution, interpretation, repeal are, my lord, completely misplaced. And my respectful submission is a declaration by the court doesn't repeal a law. A declaration by the court results in the law being stillborn. The declaration given in paragraph 75 of Minerva Mills relates to section 4, not article 31. This is very important. And Article 4 said,
Section 4.
Section 4 said, in Article 31C, for the following words, substitute the following words. Minerva Mills said, if we allow this substitution, then 31C, which was upheld in Keswanan, is radically changed, and the changed 31C, this change in 31C violates the basic structure because it dismantles the trilogy of rights, 14, 19, and 21. And the words in paragraph 75, your Lordship has read it over and over again, quoting the operative decretal order, which had first been pronounced. Was Section 4 is beyond the amending power of Parliament and is void. Let's stop there. The since doesn't matter. If Section 4 is void, it is as though it was never enacted. Where is the question, my lord, of saying parts of Section 4? It doesn't say that part of Section 4. Your Lordship's declaration, decretal declaration is Section 4 of the Constitution Amendment Act is beyond amending power of Parliament and is void. If 4 is void, and that's your Lordship's declaration, then you scrub out 4 from the statute book. 4 was stillborn, it never breathed life. Where is the question of parts of 31C going away and parts of 31C remaining? The whole of 4 was void. That's the short answer to this, my lord. And it is a nostalgic moment for me. It's a nostalgic moment for me, my lord. That's why when the Solicitor General asked me to assist, I was trying to hold fort, my lord, as Solicitor General for the state of Maharashtra, when the redoubtable Mr. Nariman argued this point first, before 5 judges. And we were first called upon to say, is there a 31C? Then, my lord, we argued 31C. Then he argued the main point about the challenge. And immediately I was called upon. I said, I rely on 31B and 39B and C. When, if I remember correctly, sitting on the right side, Mr. Justice M.B. Shah said, oh, but this resources means government's resources, not private resources. So I cited Sanjeev Kok. That's how that issue got referred to 7. Before 7, a bench headed by Mr. Justice Barucha I cited Mafatlal. That's how it got referred to 9. The issue was always about 39 B and C. If this point had to succeed, Ballot, the second issue didn't arise. If this point had succeeded, there was no question of reference. 5 judges would have said there is no 39 B and C on the statute book. We have already held it violates Article 14. End of the road. So, my lord, I submit this point it's a non-point with great respect. What one cannot superimpose rules you apply for statutory interpretation and working the General Clauses Act to Article 368 and the power of this court to determine the contours of 368. But what your lordships do is, when your lordships say it is beyond amending power, suppose, my lord, this bill had been passed by Parliament ordinarily present and voting, what would have been the result? Your lordship would have said nothing has been done. If a state assembly passed a law saying we repeal 39 B and C, would your lordship take cognizance of it? You won't. So, my lord, when your lordship says it violates 368, don't take cognizance of this section 4. Life goes on. That's the result, my lord. That's, I would submit, has to be the approach in these matters.
Thank you, Mr. Zari. Thank you.
Deeply obliged.
Thank you, sir. We'll come back after.